Hello and welcome everyone to August community meeting. Tonight, I want to welcome Erik Joffe. He is an associate with Neinstein Personal Injury Lawyers, and he's been so since 2012. His practice focuses on long-term care, home negligence, and nursing home negligence, in addition to other areas of insurance litigation, including medical malpractice, motor vehicle accidents, slips and falls, and products liabilities. He holds a certificate in elder law from Odsp Hall Law Society. Erik has argued before the Supreme Court of Justice and License Appeals Tribunal. He is a graduate of Queen's University and was called to the bar in 2013. He is a member of Toronto Lawyers Association, and he's an executive board member of the Brain Injury Society of Toronto, and he volunteers with Lawyers Feed the Hungry. So please welcome Erik. Thank you.
Thank you so much, Melissa. And thanks for having me, everyone. I've got a bunch of questions that were sent to me earlier, so I'm going to address those. But let me just first say, once again, it's nice to have everybody that's attending on in a community setting, in our new community setting. But hopefully we'll all be back together soon. I do, as a board member of BIST, I really do love getting together with everybody and enjoying our events like the BIST 5K and just anything else you guys and girls can get out to. And anyways, it's a pleasure to be here, and thank you very much, Melissa, for that very flattering introduction. I don't get that often. It's very odd to hear. So.
Well, thank you, Erik. We appreciate you.
I will just jump into some of the questions, if that's okay. I saw one on the sidebar. I'll address that in a bit. But if it's okay with everybody, I'll just start. And a lot of these questions are related to ODSP. Okay, so Ontario Disability Support. Lots of these answers. Or lots of your questions can be answered by the Ministry of Children, Community, and Social Services website. Now, I'm not saying that's the end of my presentation here, but I would encourage everybody to go to this website, and I will post it in the chat right now. Hold on. Hopefully, I'm not a dinosaur, and I can do this. Post. There we go. I'm going to send that link to everybody right now. It'll be in the chat. That's a great resource for everybody right there to answer some of these questions about ODSP. So first question I got was, what happens if I get an inheritance? Does that affect my ODSP? Under the ODSP support program, an inheritance would be considered a gift. Some of your inheritance could be exempt under the rules for gifts and voluntary payments. So I think it's up to $10,000 of the total value of all gifts, voluntary payments, and payments from a life insurance policy or a trust that you receive in a 12-month period would be considered as exempt as income. So generally, the ODSP or the ministry will treat the money that you inherit as income when they calculate your eligibility for income support in the month that you receive it. So if you get money in August, they're going to consider it when they calculate your income support for August. If you have any money left from your inheritance in the next month, say September in that example, they're going to treat it as an asset in that month. Asset rules may apply that could affect your eligibility for income support. This is all probably a lot of jargon for everybody. And I don't specialize necessarily in ODSP. A lot of our clients deal with ODSP. And we deal with ODSP or OW or CPP with a lot of our clients, long-term disability. So if you have a specific question, I just want to say, feel free to reach out to me. Melissa can provide you my email. And just feel free to reach out to me with any question, anything that you might have been wondering about, or you didn't want to type or send over, or if anything comes up in this conversation, I'm happy to answer them. And I'll just give the big lawyer disclaimer that, you know, I'm doing my best to answer questions generally. Some of these questions I don't have expertise on. I would advise you to consult a lawyer, speak to somebody at Neinstein, speak to somebody in employment law or long-term disability law, which we handle, but don't just go in alone. I would encourage you to speak with a lawyer. Most of these areas, no one's going to charge you to just sit down and have a consultation with them. So you can use the money that you get for an inheritance towards things that don't affect your eligibility for income support. I'm really sorry if you're getting any background noise right now. My newborn might be crying. I don't know if you're picking it up. Oh boy. Okay. So things like investing in a RESP, like a registered education savings plan for your kids, investing in a registered disability savings plan, which is an RDSP, and using it to buy a disability related item that has been approved in advance, or buying a home to live in. So those things would be exempted. Inheritance and trusts are also an interesting topic. If you inherit some money and you place it into a trust within I think it's 6 months of receiving it, then up to $100,000 of your trust might be exempt as an asset. Melissa and Nicole, if you want to jump in, if you guys are hearing any of this background noise, then you let me know. Otherwise, you stay on mute and I'll assume I'm good to go here.
It's only a mild, it's like a...
It's a mild, just a mosquito.
Sweet singing bowl. It's...
Two
But I
mosquitoes.
don't think most people can hear it. I just have my volume up very, very high.
Okay. Well, I'm sorry. I apologize, everybody. I do have two young kids they're sort of in the room next to me. So, anyways, I'll continue. If there's any interruption, you let me know. And yeah, it's part of the reason I have headphones here. If you inherit a trust that's been set up by will, my understanding is that inherited trusts are not considered income, and up to $100,000 of your trust could be exempt as an asset. So if you have a trust and a life insurance policy, up to $100,000 of the combined value of the trust and the cash surrender value of the life insurance policy may be exempt as an asset. So if you inherit property or possessions, again, there's a nice little bit on this on the ODSP website, or sorry, the ministry website. So the ODSP or the ministry will treat this as property or other possessions that you inherit as assets. Asset rules apply, which could affect your eligibility for income support. So there are some situations where the property or possessions that you inherit might be considered exempt. One of the things is like a house that you live in. And I know that that was sort of the root of one of these questions. So if you inherit a car and you use it as your primary vehicle, if you have a house and you live in it, those are situations where property or possessions you inherit may be exempt. Okay, the next question that we got was, my child is not able to take care of themselves. Can I leave custody in a will, or do I have to do something now? This is really, firstly and foremost, an estate law question. So I'd highly recommend whoever asked that, you can email me. I can provide you a list of estate lawyers. It's not my area of expertise. I do not do estate law. I do personal injury law. I do long-term disability, long-term care home, basically anything under the sun that deals with insurance or personal injury. But estate law is a different beast. A lot of helpful information that I sometimes get comes from consulting a firm called Hull & Hull. They have a great website. There's a bunch of written articles where you can type in a question and a lot of it pops up. And I'm going to share their website now on the chat. But again, I'm happy to provide anybody with a list of potential estate lawyers who they may want to speak to. I don't mean this to be construed as you should only use Hull & Hull. I just go to their website from time to time because they have these scholarly articles that really help inform me when I'm informing clients. So
So there is a comment, sorry to interrupt, Erik. There is a comment
please,
in the
yes.
chat box, and it says for a child, a Henson Trust. So I'm not super familiar with a Henson Trust, but I'm not certain if that deals with custodies.
Yes, a Henson Trust is, I can get into a Henson Trust. Again, Hull & Hall's website is pretty good for this, but Henson Trusts are sort of complicated, but I can go into it if somebody, sorry, do you want me to explain what a Henson Trust is? Or was that?
Yeah, I'm not certain. I mean, if you can kind of overview it in a couple minutes,
Sure.
I think it would be helpful for people who may be listening later on.
Okay. So like,
and then we got a yes, definitely in the chat box.
Oh, okay. So it's like, it's a type of trust, I think. And again, this is not my area of law, but like my understanding is it's a type of trust where it's used with estate planning to deal with situations where there's a disabled beneficiary who is entitled to receive support payments from Odsp. So I think it comes from actually a case, an old case, maybe in the 80s. But there's like a discretionary trust that was held for a disabled beneficiary that wouldn't result in a loss of government benefits like Odsp. So if somebody has assets under the Odsp or gets income under the Odsp over a prescribed limit, then they cease receiving support. An individual can't hold more than a certain amount in assets and continue to get Odsp. But I think, let me just jump to, oh my gosh, I'm going back to law school here, or the last time I looked at this. I think the trustee has to have absolute discretion. The assets of the trust, oh my gosh, don't vest in the beneficiary. I might have to look this one up. Okay, I'm looking it up.
Spot.
There's a gift following the death of the beneficiary. And I think that's the third one. Let me look it up. Hold on. Okay, that was right. Hey. All right. Earning my law degree tonight, guys.
There you
and girls and everybody. So all right. So a Henson Trust can rely on the absolute discretion of a trustee in order to meet the requirements of a trust, but it's created in a will by parents of a disabled beneficiary in order to ensure that their child's going to be properly looked after. So the parents are sort of forced to, they have to give complete trust to one person, and that person holds a lot of responsibility. So it's really, really important in a Henson Trust to make sure that somebody that you're picking is really, really trustworthy. And we'll get into this into powers of attorney for property and care, which I think is the next question. I hope I didn't muddle that answer too horribly, but I'll go into, where was I, Melissa? Was I talking about the Children's Law Reform Act?
So you were going to go into a website to look at.
Oh, that was, I in terms of the Henson stuff, I think I've answered it.
Yes, I think you've answered the Henson Trust. I wasn't certain if it was the Henson Trust or it was the Hull & Hall. My apologies.
No, that's the Henson Trust. That's what I know about it anyway. So needless to say, you guys can sorry, I keep saying that and I should correct myself. It's a course of habit and I don't mean to offend anybody by saying that. Everybody should email me if you have a question. If I don't know the answer to your question, I'm more than happy to direct you to somebody who I think might. And that happens all the time in my area of law. So we were talking, I think, a little bit about the state law question, which is my child isn't able to take care of themselves. Do I have to leave their stuff in a will? So I guess I'll just say it should be, it should be noted there's an important distinction between guardianship in terms of custody in relation to children, which you can hear, a form of guardianship of the person, and guardianship of a minor's property, where there are two parents in a custody of a minor child and one parent dies. The surviving parent automatically has a legal right to custody of the child. In contrast, a guardian of property refers to the individual appointed to manage a minor child's assets until he or she reaches the age of majority. Parents do not have the automatic legal right to take guardianship of a child's assets. They actually have to make a formal application to the court to obtain this authority. And most frequently, appointing a guardian for a minor child in a will refers to naming a custodian suitable to take the parent's place rather than a guardian of property. This seems very ironic that I'm hearing two small children in the background here. So, the CLRA is the Children's Law Reform Act. It provides the parents a right to use a will to appoint someone to assume custody of their minor child when they die. If two or more people are entitled to custody of the child and death occurs simultaneously, and there's these two subsections that are 61(4)(b) and 61(5) of the CLRA, provide that the appointment will only be effective if both parents appointed the same person as custodian. So in the event that one parent dies before the other, the appointment of the first parent to die is typically ineffective. So in other words, like the appointment of under the will of the surviving parent is the one that's going to carry the day or be in force. So the designated custodians need to be consulted to ensure that they're comfortable with the proposed appointment when the will is prepared. If you're going to make these steps and you don't want to blindside somebody, you want to make sure that there are open lines of communication with whoever it is that you are selecting for this, because it's obviously a very huge responsibility, has legal ramifications, and has ramifications to both parties. That's you, that's your child, and the person that's being appointed. So I hope that answers it, or I'm done ranting. But upon the date of death, the parent's decision with respect to testamentary custody is typically effective for 90 days, and a formal application to the court has to be made during the 90-day period in order to obtain custody of the child, on notice to the office of the children's lawyer. And when we say on notice, that means in legal jargon, you need to let the office of the children's lawyer know what it is that you're doing. So I hope that answers everything. I'll just check the
Yeah,
chats.
there's another question came in, and
About a will?
he says, speaking of a will, can it be just handwritten by the person in question and put aside, or does the will have to be stamped by a law of authority?
That's a very, very interesting question. I don't know. Again, not an estate lawyer. Handwritten wills, in my understanding, can have legal force and effect. So yes, a will can be handwritten, and you can check TMZ for a lot of this stuff, but people write wills handwritten on their deathbeds, or handwritten because they're under undue influence from other members of their family, or whoever it happens to be. And those wills can go to court, and they can be litigated, and those wills can prevail over the will that was written 6 years prior to that, or even 6 months prior to that. So there's a lot of a very interesting litigation that comes from this topic, which is wills. You need to be very careful with the language that you use. And a lot of the time, my understanding is a judge will look at a will and say, what was the intention of this person? If they didn't use the correct legal jargon, like what did this person intend, or what did they have in mind when they were writing this? So there's a law. There is some flexibility or latitude for a judge to be able to interpret a will. But these wills can get very litigious, which means they can go to court a lot, because some people will say, well, that's, my grandpa, my dad, my mom, whatever it is, wrote that version of the will when they were being influenced, or when they were being pressured by this family member, and they didn't have capacity to make those decisions or to make those wishes of their will known at that time. So it can get very ugly, and I think we've all seen, or you can look up any sort of news article about it, but I don't know a lot about it. All I know is that you can have a handwritten will. What I would encourage you to do if you're considering to actually create a will, I think everybody should have a will. You can go online and have a template, but speak to an estate lawyer very briefly. And I would encourage anybody who has a question like that to take it up with an estate lawyer, because that's just sort of a bird's eye view from somebody who does not practice in that area. The next question that we had was, do I have to have a power of attorney? So power of attorney, or POA. I guess short answer, no, you don't have to have a power of attorney, but it is entirely voluntary. Like legally, by law, it is entirely voluntary. You do not have to have a POA, but it could be a good idea in some circumstances. So it depends on a lot of factors, which is like the most lawyer thing that in terms of an answer that you'll hear. It depends. What are the circumstances? But I say that because every case is different. Circumstances are different. Everybody's end goal is different. So I'm not just saying that in a flippant way. If something happens to you, for example, like an accident or an illness that impacts your ability to make financial or healthcare decisions for yourself, you will need someone to make those decisions for you. So you need to consider having a power of attorney in place, regardless of your age or your financial situation. So power of attorney is a legal document that gives someone you trust the right to make a financial or a healthcare decision for you. So we're going to be talking about two types, or I'm going to be talking about two types. It's a power of attorney for property. Now I'm wearing suspenders here. Okay. A power of attorney for property, or a power of attorney for personal care. They're different. And we're going to hear the term capacity. And capacity is different in legally speaking, in like 5 different contexts. So bear with me. I'm going to try and flush this out a little bit. But again, this is an area of law that there's like volumes of books written about. So again, 2 types of POA, or power of attorney: property and care. And an attorney for person. And when we say attorney, this is someone that's been appointed. You don't have to be a lawyer. Anybody over 18 in most cases. So an attorney for personal care can make decisions about what? They can make decisions about your health care. That's a big loaded term. Housing and other aspects of your personal life, like meals and clothing. If you don't have an attorney for personal care, my understanding is that your family can make some of these decisions, but not all. And anyways, I'll go into a power of attorney for property, because I'll give some examples for that as well. So what is power of attorney for property? What are they making decisions for? They're making decisions for your financial affairs. Big, broad term. Paying your bills, collecting money owed to you, maintaining or selling your house, managing your investments. So that's a big aspect of anyone's life. So power of attorney for property. Without one, your family, including a spouse, can't automatically step in to make financial decisions for you. They might have to go to court to become your court-appointed guardian. So the government may have to make decisions for you. That's the government. That's the OPGT, Office of Public Guardian and Trustee. That's sort of the last resort. Family members should be able to take over after that, but I'll give some examples for continuing power of attorney for property. So you need to have mental capacity. What does mental capacity mean for power of attorney for property? In this situation, it means you have to know what property you have, what's the approximate value. You need to be aware of your obligations to the people who depend on you financially. You need to know you're giving your attorney what you're giving your attorney the authority to do. Again, we're using the word attorney as the person you're appointing. Know that your attorney is required to account for the decisions they make about your property. Know that as long as you are mentally capable, you are able to cancel or revoke the power of attorney. Understand that if your attorney doesn't manage your property well, its value may decrease. And understand that there's always a chance that your attorney could misuse their authority. So incapable of managing property means a person can't understand the information about their property or finances, or is unable to appreciate what could happen as a result of making a certain decision or not making a certain decision about these issues. Just your opinion. Should one have more than one POA just in case something happens to the main POA? In my opinion, I don't really have an opinion on this stuff because it's not my area of law that I specialize in. But I would say, wow, you could have a POA in the alternative, I think. But generally speaking, you want to have a power of attorney for property or care. Somebody that, unless something very fluky or unfortunate happens, like you don't want to pick somebody who's very elderly or frail. Again, there are exceptions to this, so don't hold me to it. But I would say you are allowed to pick joint POAs. So that is absolutely an option. You can have siblings or two parents or whoever it is that you wish to appoint. My understanding is they need to come to a consensus before decisions can be made, and there's a dispute resolution process involved. But there's no harm in appointing more than one person necessarily, and there's certainly no harm in appointing somebody as an alternative. Again, very, very sort of 50,000 foot view there. Okay, power of attorney for personal care. Anybody who's 16 years or of age or older who's mentally capable of making a power of attorney for property or care can do so. So what level of mental capacity is needed to make a POA PC? In this situation, mental capacity means that you understand whether the person that you name as your attorney is actually concerned with your well-being. You need to internalize this. You need to be able to express that understanding to somebody who's asking the question. You also need to understand that this person may need to make decisions for you. And that really does relate to your health. Okay, so should I have surgery? Should I not have surgery? Do I have a do not resuscitate? Should I be in palliative care? These are big questions, big life questions. So it's really important to, I would say, to have a conversation with whoever it is that you're deciding that you might want to appoint, to go over these questions, to go over your wishes, so that it's not just written in some document. You've had a conversation with this person. They understand you as a person. They understand what's important to you in terms of your health. That is extremely, extremely important. So what kind of decisions would a POA for care be allowed to make? So unless restricted, they can make almost any decision. of a personal nature that you would normally make for yourself. Decisions about medical treatment, housing, food, hygiene, clothing, safety. Like these are all personal care decisions. That's the end of my rant there. So I'll jump into a different topic if that's all right with everybody. And again, anybody just feel free to jump in and tell me to slow down or continue to talk about a certain topic. But this one is an LTD question, which is long-term disability. So the question is, what steps can be taken if my long-term disability application is denied from my workplace? So I guess I don't mean to be, smart about this, but generally speaking, it's not your employer. It's not your workplace that denies your LTD, your long-term disability. It is your private benefits provider through your work. So somebody, I'm not naming them because they're the usual suspects, like Manulife or Great West Life. These are just examples. Like most of the time, your lawyer isn't actually even privy to the reasons you were accepted or denied LTD. So if the application is denied, then you really want to you don't want to get this verbal. You really want to get a written denial, and that written denial should lay out the reasons for that denial. And there is, generally speaking, a process where you say, okay, I was denied LTD. What do I do next? It'll lay it all out in the policy. In your private benefits and your work benefits policy, there's going to be this LTD section, and it's going to lay out what can I do next? What's my eligibility? Are there any exclusions to getting LTD? If I have a pre-existing condition, if my illness is a result of a flood or famine or war, there's a bunch of exclusions that you should pay attention to. And most people, other than the personal injury lawyer who's scared of his shadow, don't read into on a day-to-day. So read it. Read your policies. If you don't understand something, ask your provider to explain it to you. It's so often, that we treat these policies like a cell phone. You download an app, and you scroll to the end, and you just click whatever. They're important. They have lasting effects if things go wrong. And of course, the personal injury lawyer is telling you always think of the worst and plan for the worst, hope for the best. But it's important. It's important if you have a question about this. Our firm, I would encourage you to reach out if you have an LTD question. Send me an email. I'm more than happy to answer anything related to LTD. This is something that I deal with a lot. Okay, so generally speaking, you can appeal your long-term disability. It's sort of an internal appeal process. You say, hold on, you should consider this, that, the other. And generally, that's like a letter from your doctor or further medical information. Maybe it's just you saying, reconsider this. You didn't look at the full picture. And there's a series of appeals that can be exhausted. But what I would say is, like, look, get the denial in writing. If you disagree with the decision, consult a lawyer, call our office. I'm happy to answer the questions, as I said before. Like, the other component of this is speak to your treating physicians, like your family doctor, your specialists that you're seeing, your psychologist, psychiatrist, your physiatrist, your orthopedic surgeon. Like, these are the people. They are the ones who filled out the forms and documents that went into your application for LTD in the first place. So you need the support of your physicians in order to win an LTD case. If your own physicians are saying, they can probably go back to work, they can work part-time, like, you need to understand that. Because if you don't understand what the positions of the people that you're going to call and bring to your aid or bring to your side when you're litigating this, then you're going to have a big problem, because it's all based on medical evidence. Not all of it, Some of it is my charm. But all joking aside, you really need to understand what your doctors are telling your long-term disability providers about what you can or can't do. It's very important. So you need their support. Medical evidence usually carries the day. No questions, so I will hop to the next one. Oh, this is one I'll just. What can I do if my ODSP worker is not letting me access money for things that other people are getting? Can I be kicked off ODSP if I try to access extra money? I'm not exactly clear on this question. So if somebody wants to be more specific or rephrase it in an email or anonymous email to BIST, I'm happy to try and answer it in writing or find somebody who might be able to help. So I'm sorry, that one I'm not exactly clear on. I don't want to go on some crazy tangent about what I think. Yes, perfect. Thank you so much, Melissa. So will ODSP make me go on OW? So will Ontario Disability Support make me go on Ontario Works if I start working part-time? I don't know if I can keep a job, and I'm afraid I won't have any support if I can't work. So I interpreted this in a certain way, and I'll answer the question the way that I interpreted it. So I apologize if this doesn't get to the heart of the question of the person who posed it, but I think what we're asking is, can I work and still get ODSP income support? Yes. The answer to that is yes. You can work if you're still receiving financial help from ODSP. So in some cases, if your earnings are too high, you might no longer qualify for ODSP. But how is your work going to affect ODSP income support? My understanding is that you can earn up to, I think, $200 a month without having your income support reduced. If you earn more than $200 a month, then only 50% of your net earnings or business profits, if you're self-employed, over $200 are deducted from your income support payment. If you're attending a secondary or post-secondary school full-time, then they don't deduct any earnings from your ODSP income support. I would encourage anybody who has more questions about this to talk to your caseworker, find out more about how your earnings or your business profits will specifically affect your ODSP income support. Caseworkers are there. They might not always have the questions, but if they don't have the questions, escalate it. Ask to speak to somebody who does. Like that's their job. Their job is to answer your questions and to make sure that you're not doing something that's going to get you in trouble with ODSP. So, and that would just be it through inadvertence. I'm not saying hide or lie ever, but just doing things and not understanding what the repercussions might be could end up leading you down a path that you don't want to go down. So talk to your caseworker as well. And again, if you have any other questions about ODSP, I'm happy to answer them. You can always email me. And yes, research. That's that's a lot of what went into tonight for sure. So another question is, what kinds of compensation am I entitled to if they force me out of my current position? And then what kind of steps can I take to proceed to pursue it in court? What would the cost be for me for such a proceeding? So this, my understanding is it relates to an employment law question. Someone being let go of their job. Again, not an area of my specialty. I'm not familiar with what costs would be usual for employment disputes. So I don't know. To answer that question about like how much is it going to cost, I don't know. An employment lawyer would probably be able to answer that. And yes. Speak to a manager or supervisor. Sorry, I'm just watching the chat as well. So I guess that question is answered as such. Like I can't tell you how much it's going to cost. I would imagine it varies depending on the complexity of the contract, how long you've been employed for, what the nature of the dismissal is, constructive dismissal, and I'll get into that, or frustration of contract, what is being claimed. That much I know can vary quite a bit. So I will get into that. But if you have an employment law question, you can email me and I will put you in touch, or I'll give you a list of employment lawyers who I think do good work, or I'll put you in touch with the Law Society of Ontario's referral source website, and hopefully somebody can answer your question more in depth in terms of like how much it's going to cost you. Okay, so the term forced out, I think is loaded. I don't mean to answer that again as like a lawyer, but I'll talk about two different terms that we hear a lot about. One is frustration of contract, and then the other is, well, let me talk about frustration first. Frustration of contract. So an employer can deem an employment contract to have been frustrated by an employee's inability to work. We see this a lot. There's no set amount of time. There's many cases in which employees have been off work for years, and the court said that their contracts have not been frustrated. So the courts will assess whether there's any reasonable likelihood that the individual will be able to return to work in the foreseeable future. If there is, then it's unlikely that a court would conclude that this type of contract of employment has been frustrated. So there's a case before a couple of years ago against like a big box employer. An employee had been off work for like 5 years. The big box employer had terminated that person, and the termination was based on the family doctor's report that basically said it's not possible that this person, it's not possible that the doctor could indicate, let me just read my notes. It indicated that it would not be possible to state when this person could return to work. Okay, so they said, because we don't know when you're going to return to work, we're going to fire you. Frustration of contract. So that person sued for wrongful dismissal. The big box employer lost primarily because there was no medical evidence to support a conclusion that there was no reasonable likelihood that that person could return to work in the reasonably foreseeable future. So the other aspect of this case is, in light of the large scale operations of this big box store, there's no basis whereby a conclusion could be reached that this person's ongoing absence hurt the company in any meaningful way. So as a result, continuing to accommodate that person by allowing that person to remain on leave did not constitute undue hardship. So there's a bunch of expressions that are commonly used to describe situations where employment is terminated: let go, discharged, dismissed, fired, permanently laid off. Under the ESA, or the Employment Standards Act, a person's employment is terminated if the employer, three things here, dismisses or stops employing the employee, including where an employer is no longer employed due to bankruptcy or insolvency, constructively dismisses an employee and the employee resigns in response within a reasonable time, and lays an employee off for a period that is longer than a temporary layoff. Now, all of those terms in those three factors have probably their own podcast. So again, if you have questions about any of the stuff that I'm talking about, please let me know. Nicole and I are great resources to put people in touch with employment lawyers. In most cases, when an employer ends the employment of an employee who's been continuously employed for 3 months, the employer must provide the employee with either written notice of termination or termination pay, or a combination, as long as the notice and the number of weeks of termination paid together equal the length of the notice the employee is entitled to receive. That's a mouthful. But the ESA doesn't require an employer to give notice to an employee, the ESA does not require an employer to give an employee a reason why his or her employment is being terminated. But there's some situations where an employer can't just terminate an employee's employment, even if the employer is prepared to give proper written notice of termination. For example, a person can't end someone's employment or penalize them if part of the reason they're terminated is based on the employee asking questions about the Employment Standards Act or the ESA or their rights, such as refusing work in excess of daily or weekly hours or taking a leave of absence specified in the ESA. So that's called the reprisal. We're at 7:37, so maybe I'll skip ahead a little bit. What's constructive dismissal? It can occur when an employer makes a significant change to a fundamental term or condition of employee's employment without the employee's actual or implied consent. This is all sounding like a tongue twister to me. I hope I'm enunciating properly. And also, a big congratulations to me. My kids are asleep.
Congratulations.
Thank you. Thank you. Well, you know what? A big congratulations to my partner. Actually, I'm just here speaking out of screen. So, okay. So, an example of constructive dismissal. Somebody can be constructively dismissed if the employer makes changes to their terms or the conditions of an employment, such that you have like this significant reduction in your salary or such a significant negative change in your work location or your hours of work or your authority or your position. Constructive dismissal can also include an employer gives an employee an ultimatum: quit or be fired, and the employee resigns in response. So you would have to resign in response to changes. You have to respond or resign within a reasonable period of time in order for the actions of the employer to be considered termination of employment for the purposes of the ESA. It's very difficult. It's very complex. Termination, constructive dismissal. Holland, Holler, great. DeVry or Devry and Smith, which Nicole has just listed in our chat. They're great. And again, feel free to reach out to our firm or reach out to Melissa. She's happy to connect you with me, and I'm happy to connect you with an employment law specialist. Next question is, would early retirement be a viable option, or should that be the last resort, as it would forfeit my eligibility for other sources of income such as EI or employment insurance? Whoa, that's a loaded one. Hold on one second. Just need some water. I've been talking all day, but that's what I do. So early retirement is really tricky. I just dealt with this in the case of mine, where somebody opted not to get LTD, long-term disability. They said, you know what, I'm going to get paid more retiring early. I'll collect my pension, I'll collect this and that, and I'll just say goodbye. And then one of the defendants turned around and said, you didn't apply for long-term disability. And because you didn't apply for long-term disability, we are going to deduct our award for your past and future loss of income on the amount of money you would have gotten if you had been awarded long-term disability. In my opinion, hugely inequitable thing to do. In the law, it is a very much gray area, because were these benefits available to you at the time? So it's a hugely loaded area of law. What I would say is, if you're giving up the right to private benefits that might be available to you, long-term disability, then I would consider it. I would speak to a lawyer. And the reason I say that is, I say that in the context of somebody that's hurt or disabled or injured. So I see this in the context of personal injury cases. Somebody retires, as I said, makes more sense to them than applying for a long-term disability, fighting it out with an insurance company, hiring a lawyer, and so on. But it really can affect your potential claim, because the defense lawyer can do exactly what I just suggested, which is to say we're deducting this or that. So if you are deciding about early retirement, it's in the context of an injury or disability. Are you deciding against, or are you deciding between going on long-term disability versus just hanging up the towel and saying, I'm just going to retire? Speak to a lawyer, call our firm, call me, email me. I'm happy to work through it with you, because it is a very complex area of law, and it really has a lot to do with contracts, policy, long-term disability, case law. It's, I spent 3 weeks researching this area, and it is very interesting to say the least. Read your employment contract, read your benefits policy. As I said before, if you don't understand it, ask your employer, ask your benefits provider, consult with a lawyer before selecting retirement, if a disability or personal injury is involved. That's what I would say. I'm happy to discuss this further. Okay, can I own a house if I get ODSP, or will I have to sell it? Did I answer that already? I don't think so. Yes, you can own a home. So there's some examples of things that you can own that won't change the amount of income support that you get. I think, again, this is just based on my research, but the home you own and you live in, necessary household and personal items, furniture, clothing, your primary vehicle, and then there's like these registered investments. So RESP, Registered Education Savings Plan, RDSP, Registered Disability Savings Plan, trust funds, starting with an inheritance or life insurance policy up to certain limits, cash surrender value of insurance policies up to certain limits, and prepaid funerals, as dark as that sounds. So speak to your ODSP caseworker to learn about some of these other assets. Some of the assets, depending on their value, which assets may affect whether you're eligible or continue to be eligible for ODSP. That's sort of something I looked up and I know a little bit about as it relates to this question. So I'll just say like some examples of depending on their value, they can change the amount of income support that you get for ODSP or how much you're eligible for. Cash in hand, money in your bank account, are RSP, Registered Retirement Saving Plans, TFSA, tax-free savings accounts, property other than the house you live in, vehicles other than the main vehicle you drive, trust funds, investments, collectibles, stamps, antiques, cards, that kind of thing. So those things can affect you as well. So we're a little bit early on that, on finishing here, but I'm getting hoarse here, so I'm gonna let Melissa jump back in. I love a captive audience, so thank you for listening to me, everybody, and please feel free to email me if you have any other questions related to these topics.
Oh, so a comment just came by, and I actually don't know anything about this, but a comment just came into the chat saying that you can't have life insurance if you're on ODSP. Yeah, I'm not very well versed in that.
I thought you could have 100,000 held in trust, but I could be wrong.
Yeah, so I guess that's
I think it's like if the amount of the cash value, the share shares received by an ODSP recipient or member of the benefit unit is over the asset limit, receipt of the cash or shares may not result in an income deduction. Life insurance policies with a cash surrender value of up to 100,000 are exempt assets. That's my understanding, but I could totally be wrong on that.
Yeah, so I guess if you're considering having life insurance, yeah, talking to your work would be the best bet. Yeah, I don't even really know much about life insurance, so.
That's about as extensive as my answers.
Yeah. There we go. That was a good way to end that. And so somebody else said, I wish to comment previously that I didn't ask a question and possibly if another, possibly we had two of the same person. So if you want, you can go ahead and type your question in the chat box and we can address it to Erik. He has a couple more minutes and then we're going to be kind of closing it down for the evening because he would probably love to join his little ones in Sleepy Land. So I'll just give you some time. I'll kind of chat over. But I mean, if you have a question, then go ahead and put it in there. And as soon as I finish up, then I'll address it if it's in there. But I do want to just take take a moment to say thank you to Erik. It's always a pleasure having you. And thank you for all of your research and your extensive answers to the questions that popped up. Actually, I'm just remembering now that before you came in, there was somebody who did actually have a question about, okay, so I'm not certain if you would be able to answer this, but somebody did have a question about long-term care or private care or things like that. And so she was wondering what kind of money does she need to have in order to afford private care in her home. And then as well as their social assistance for people with brain injury. So I think she's kind of going between long-term care, seniors homes and things like that.
Yeah, it would depend. It depends. Are you in a nursing home or you're a long-term care facility, like a long-term care home in Ontario? There are long-term care homes where you don't have to pay anything. They're completely subsidized by the government. There are long-term care homes that are partially subsidized for the government. And you're able to supplement that with, say, a personal care support worker or attendant care support worker comes in, or even sometimes a family member. So it really depends, but you don't need to have any money to be able to be placed in a long-term care facility. If you have a question about long-term care, that is something I know a lot about. I'm happy to answer any questions in a more detailed way if you want to reach out to Melissa or if you want to reach out to me.
So this member actually has a harder time typing. So she's just raised her hand so that she could speak her question.
Oh, of course, Stella,
so I'm going to go ahead and unmute. Is it working? There we go.
Oh, might have hit it twice.
I think I did.
Oh,
there we go. Hello, Stella. Sorry.
So my situation, that's okay. My situation, Erik, is that I am on LTD and CPP disability. I'm 58, but I wonder if my illness progresses and gets worse, like even 65 and older. And so therefore I don't have a lot of money. Would I be able to even have somebody come into the apartment that I live in now to assist me with, like, I guess a PSW, etc., for a low amount of money? Or
okay,
social assistance through the government, that type of thing?
Yeah, okay. So that's thank you, Stella, for that question. So you're getting LTD, you're getting CPPD. What those amounts are used for, right? Those amounts aren't going to necessarily change based on, I need somebody to come in to my own home. So that, let me just answer that. Like those amounts for CPP and LTD, those are determined based on, do you meet the test of severe and prolonged? Do you meet the test of, complete inability to do any job that you're reasonably suited for, or whatever the contract or policy says for you. So I guess part of your question was, how much money is it going to cost me? and where do I find the money to find somebody to come in to take care of me and any sort of additional support. What I would do in this situation, Stella, is again, CPP hasn't been cut off, LTD hasn't been cut off. I might explore a couple of different avenues. I might look into what your LTD policy actually says in terms of will they provide additional support or care over and above what they might be giving you for LTD, for just that monthly payment. And I might also talk to your family doctor. Somebody over 65 has certain entitlements to social support programs that somebody under 65 may not. So for an example, somebody over 65 that injures themselves can have OHIP funded physiotherapy or additional help from the CCAC that may come in. So talk to your family doctor about some of your concerns, about some of your care needs, and hopefully your family doctor and you and maybe even your CPP, if there's somebody assigned to your CPP case, can work through what additional supports that you need and try and find some government accessible programs to help you out.
Okay, so it sounds like there's hope.
There's always hope, Stella.
Okay. Thank you very much.
No problem. Do you have a good relationship with your family doctor?
Well, I do, but unfortunately, he's retiring in a couple of months. But it's understandable because he's been my doctor for like 36 years.
Okay, so
But
try.
I will miss him.
I would say try and ensure that there's some transition of care with your family doctor. I don't know if their office is gonna assign somebody else, but make sure you have a family doctor and get in to see your family doctor before they retire. See if your family doctor can help, especially a longstanding patient of theirs, to make sure there's proper transition of care and to make sure whatever government resources are available to you that your family doctor is signing off on.
Okay, thank you.
No problem.
Thank you, Erik.
It's my pleasure, Melissa. It's nice to see you virtually.
Yes, if nothing else, it's but hopefully that will change soon. You know?
Hopefully we'll see we'll be able to see somebody at the run walk or roll. That's one that's near and dear to me. When is it? September 26th?
Between
the in-person, and then there's the October.
the in-person, yeah. So then the October one is the 1st to the 11th. But yeah, the launch.
Either way, I'll be there with my screaming children in tow, so everyone can meet them in person there. But okay, so everybody, thank you so much. I have to
Absolutely
jump off. That's okay.
Thank you so much, Erik, for coming today, and thank you to everybody else for all of your comments and questions. Erik, as always, it's been lovely, and I will see you at the end of September, if not then October.
Absolutely. Take care, everybody. Thank you for your questions. Thank you for your time. And as I said before, feel free to email or call me or go through Melissa if you have other questions. Okay.
Thank you very much.
It's my pleasure. Take care, everyone.
Have a great evening, everyone.
Bye now.